really thrilled to have so many of you attending. I think it speaks a lot to the solidarity of this movement we care so much about, the industry, as well as the various stakeholders coming together and listening in, participating, and also learning how they can help with the final push related to this incredibly exciting thing going on at the federal level. So we will get cranking here in just a second or two. And I'm just seeing all these VIPs saying hi, so I really appreciate Maureen and Elliot and all my friends are popping on. So our friends from South Dakota, it's a nationwide audience. We really really appreciate it. So it's about 2 minutes after the hour, and we have a tremendous amount of information to get through. My name is Brian Vicente. I'm with one of the founding partners of the Vicente LLP law firm. And, our firm has been, essentially working with anyone from the White House to Congress people to various industry stakeholders and trade associations on this change for about 18 months. So we're really looking to give you, the attendees, sort of an inside view as to what's going on, how you can participate in this incredibly important process. And we had, I think, 1,000 people register for this event, which is really humbling, but also I think speaks to the fact that this is an industry that's coming together, and we're going to push for this change because it's just been too long. It's been 50 years that cannabis has been a Schedule I controlled substance right next to heroin, and now we have a proposal to move to Schedule III, and the time has come to get that done. So very quickly, just the opening remarks. I think this is a historic moment. It's the biggest thing to happen in cannabis policy at the federal level in 50 years. And it's also just going to have a large and meaningful impact on both large and small cannabis business operators. And we'll talk about the tax issues related to that, but it really can't be understated. It's an incredibly important business change, but also is an incredibly important policy shift that we're staring at that could really accelerate the move towards descheduling altogether. So we have an incredible crew of speakers, and maybe we can go to that slide. We are going to hear about the fundamentals of rescheduling. What are the steps from here? We're going to hear about international treaty issues. We're going to hear about the economics related to this. We're going to hear about the important tax issues and so forth, business issues, some criminal justice stuff as well. And there's a ton of the brain trust from the Vicente law firm, but we also are thrilled to have Mitzi, our friend from Citrin Cooperman, a CPA, to sort of talk about that piece as well. One piece of sort of housekeeping, we do have a Q&A function, which should be available on your Zoom screen. Please go ahead and provide questions there. We will try to spend the last 15 minutes sort of compiling and addressing those questions. We also will follow up with folks with resources, as well as a transcript of this meeting, and also try to answer any questions that we don't get to. So with that, I'm gonna turn it over to my partner, Sean Hauser, who's largely been the tip of the spear for our firm on this, and we'll jump right into it. Sean?
Great, thanks, Brian. Excited to be here with you all, and just gonna jump in at the top to go over what Schedule III will and won't do if this rule is final, for which there's lots of work ahead to get there, which we'll talk about later, and then we'll jump into process. So, to me, one of the most significant and long overdue pieces is that the US government is finally and officially recognizing the safety and efficacy of cannabis for medical use, which it's been plain and simply ludicrous that it was ever in Schedule I and stayed there for so long. And we all know it was there for, discriminatory reasons and used as a tool for such. Here in Schedule III, it would be deemed to have an accepted medical use and treatment, which voluminous science and medicine supports and are lower potential for abuse for other drugs. I think this really can change the paradigm as far as public opinion and legitimacy in the medical community, which could have long-reaching and dramatic impacts. The medical community and physicians have a huge role in advancing evidence-based medicine, including cannabis. And with the FDA, HHS considering state data and medical programs, I think there's going to be a shift in engagement and public opinion by doctors, universities, and medical institutions, and just not classifying marijuana as one of the world's most dangerous drugs, which it is not, it's just going to be a signal to everyone that, you know, reefer madness is coming to an end. We're in a new era where marijuana is recognized as medicine. I think it's important to remember, you know, I think everyone, all stakeholders agree, descheduling and, you know, criminal justice reform and legalization and regulation is the end game here. That's the appropriate structure for cannabis. But this administrative process is going to get us halfway down the field there, you know, much further than we were before. And, you know, historically, you know, DEA has not proceeded, you know, with this process properly, often citing the research it overtly blocks. And, you know, Biden initiated this historic process. Schedule 3, given marijuana's relatively low potential for abuse, but some potential for abuse, is, you know, potentially the best outcome that could have resulted from this historic process. And I think rather than not thinking of it as not going far enough, we're still, you know, we've got work to do to the end game, but it's a significant shift towards that and a key stepping stone to the ultimate solution, which is of course necessary for criminal justice reform in a responsible industry. But, you know, really descheduling was not likely to happen in this administrative process. But without Biden's initiative, you know, we wouldn't have had this process and gotten this far and caused HHS DEA to apply a new, more favorable standard to medical use and treatment that considers state data. And on that note, of course, you know, importantly, this does not decriminalize marijuana. It doesn't achieve imminently needed criminal justice reform. Descheduling is the ultimate goal. Schedule 3 drugs are still controlled substances, subject to rules and regulations. Trafficking in them without proper licensure means facing criminal prosecution. Descheduling is sound and sensible public policy. It's supported, in my opinion, by the science and the law. And, you know, marijuana simply doesn't belong in the CSA, is more appropriately legalized and regulated. You know, like alcohol or other substances, and federal prohibition has led to, you know, direct public health harms and disproportionate societal harms placed upon people of color. You know, Biden has taken some steps to release federal prisoners. The vast majority of cannabis arrests are at the state level, you know, where he's called on governors and leaders to take steps to erase convictions. But, you know, the work ahead is, you know, moving the rest of the way down the field towards rescheduling. But it's important to remember that Schedule 3 does still criminalize cannabis and leave it under the purview of DEA. I do think it's going to influence more states to decriminalize medical and adult use cannabis and give us congressional momentum for descheduling, which we'll talk about more below. And this is, you know, it's a historic step in the right direction, further away from prohibition. It's, you know, a biggest step forward in federal drug policy in the last century. I think it's a significant shift for medicine and a key stepping stone to the ultimate solution. And we'll talk in depth about the removal of the 280E provision with Schedule 3, which is obviously very significant. And I think it's important to unpack, you know, the likelihood of that to support a healthy industry that's going to free up capital needed to support further reform efforts, you know, research, investment, you know, to get us to descheduling. And that's the kind of momentum in a healthy industry we need. And by establishing the legitimacy of cannabis as medicine, you know, we can more materially engage the industry like we are here today and the medical community, and more effectively persuade and influence legislators and leaders across the political spectrum. One, you know, misconception I wanted to address that's important is its impact on research. You know, while we are optimistic that moving marijuana into Schedule 3 could reframe how DEA views marijuana, could free up capital to support research, there are still significant restrictions, largely arising out of the 2022 Medical Marijuana and CBD Research Expansion Act, which makes regulatory burdens applicable no matter where marijuana is placed. So we still have work to do to, you know, ensure there's vigorously pursued research in cannabis. But we hope that Schedule 3 frees up capital for such and reframes marijuana in the minds of DEA so that they eventually start expanding research opportunities. Also importantly, this does not make marijuana state operations legal. They are not selling FDA approved drugs, and they are not licensed or meet the control requirements for Schedule 3. So cannabis and state legal dispensaries will remain in clear violation of federal law. There's no reason to believe the FDA and DEA will change enforcement priorities to interfere with state programs, as they haven't done in Schedule 1, and is frankly a testament to the relative safety of marijuana when it's regulated responsibly. We understand that there's efforts underway on a Cole Memo 2.0 to ensure the enforcement priorities stay the same. I think we've seen with the hemp model that the FDA doesn't believe its framework is appropriate for cannabis and is looking to Congress to develop a model, which is the work ahead. A change in federal enforcement or resources would be a significant departure from the longstanding approach, which I think is unlikely to change. So with that, I will turn it over to Jason to go through what's ahead in this process.
Thanks, Sean. Yeah, so I am going to discuss kind of where we are in the process and where we're going to be going, as well as some potential roadblocks that we could see. But first thing I do want to mention is that we are, from what we're hearing, we are now in the rulemaking stage, the very early part of this rulemaking stage. And just to be clear, until 30 days after the final rule is published and pending any court intervention, marijuana remains a Schedule 1 drug until 30 days after the final rule is published. So for the timeline, basically what we're hearing is that DEA has sent the proposed rule to the Office of Management and Budget. They have up to 90 days to review the proposed rule and send it back to DEA. From what we're hearing, this process should go a lot quicker than 90 days, but they do have up to 90 days. The DEA, once they receive back OMB's decision, they'll publish a proposed rule in the Federal Register and provide between a 30 and 90-day comment period. 90-day would be a bit extreme. We don't expect it to be that long. We do expect it to be around 60 days. And during this time, DEA may also grant an administrative law hearing. This hearing runs much like a court proceeding. It is administrative, but still has provide evidence, has witnesses, and so the timeline for that is unknown. Could take as much as a year. Again, we expect if they do hold a hearing, we do expect it to be a bit more expedited. Once the comment period and if there is an ALJ hearing is held, then once that concludes, DEA will take all of that information from both the hearing and the comments. They have to review it all. They have to respond to it all in their final rule. And so that could take a lot of time. Again, there's no set statutory requirement for how long this can take. So it's really unclear how long DEA will take to review all those comments. If there's political pressure and the agency really wants to get this done, then it could, again, go quickly. If not, then it could take a year or even longer. But once DEA issues its final rule, it doesn't become effective for 30 days. And within this time, aggrieved parties with what's called standing can seek judicial review. Basically, to have standing, you have to show that you've been particularly aggrieved by the decision, which I think would be a bit difficult. But as we've seen, SAM today, I think there was an article announced that they're currently raising money for potentially fighting this through litigation. So it's definitely possible. Some potential roadblocks that we can see. We could see this throughout all the comment period, the hearing, litigation, as well as if Trump wins the presidency, we could see it next year, particularly under treaty obligation arguments. But the roadblocks really kind of fall into two categories. A lot of opponents are saying that marijuana cannot be put into Schedule 3 because of treaty obligations, international treaty obligations, or because HHS implemented this quote unquote new two-factor test to determine that marijuana had a medical efficacy in treatment. As far as both of these go, we believe that there is sound legal arguments for marijuana being in Schedule 3 under treaty obligations, as well as the two-factor test that HHS used. Under treaty obligations since the 70s, the DEA has basically said that marijuana cannot be placed outside of Schedule 2 because of treaty obligations. To be frank, I think this is just an incorrect analysis of the treaty requirements. I've been reviewing the treaties for years now, and there is a very clear pathway, and it actually promotes the treaties even more with marijuana in Schedule 3 because the treaties promote the medical use of controlled substances and an application for therapeutic uses. Schedule 1 completely prohibits that. Schedule 2 would make it difficult. Schedule 3 would be the most sound place for that to lie if you're wanting to comply with treaty obligations. As far as medical and scientific determinations, the Supreme Court has said that agencies can change their mind on how they analyze something. This two-factor test didn't really change anything about the analysis. What it did change was a DEA analysis of medical and scientific application for marijuana. DEA is an enforcement agency, not a medical and scientific agency. So the fact that HHS, I think, finally determined that they should be the ones to really set out what constitutes currently accepted medical use makes more sense than leaving that with DEA administration. And so again, I think both of these are easily overcome. One thing I do want to say about treaty obligations is if we do have a Trump presidency and the Attorney General does have an issue with marijuana in Schedule 3, under the United States Code, the Attorney General is permitted to schedule marijuana pursuant to treaty obligations in any schedule they want. So they can skip this whole process, put it back in Schedule 1, and then you have to go through litigation to discuss why that is inappropriate. And so there are still some roadblocks ahead, but overall, I think we don't know the timing. That we do believe that this will end up with marijuana in Schedule 3. It's just unclear about how long it'll take to actually make that a final determination. But yeah, I'll hand that off to Charlie to talk about some Schedule 3 impacts.
Okay, so for these impacts, let's just assume that schedule, it's been moved to Schedule 3. It's been in the Federal Register for 30 days, so it's official, right? So, and at the same time, we can also talk about what it means today, right? So, let's say, the second this thing becomes official, 280E goes away. There doesn't have to be any subsequent governmental action. So that's in my view, right? That's the major benefit of rescheduling, right? I mean, it will automatically add cash to everyone's pockets right off the bat, just because of a substantially reduced tax burden. I'll let Mitzi talk about the tax details, since it's a little bit beyond me, I think. But the point is that it's going to result in an infusion of cash into the system, just from a perspective of people have to pay less taxes, so your profit on an after-tax basis is going to be higher, and that's more cash to reinvest into operations. There'll also be more money coming in because I think that this is going to spur investor sentiment, which you've already seen. If you're following the public stock markets, right? The stock started ripping the second this became public news. I mean, obviously the public cannabis stocks move pretty fast all the time, more so than other stocks. In terms of capital markets, right? So once it's Schedule 3, I don't think this is going to change NASDAQ to New York Stock Exchange official listing requirements. Their view has always been that you can't hold a cannabis license and list. Now, you've seen some pretty creative structures with exchangeable shares, which have become quite popular, and people sort of uplisting in Canada using that mechanism. So I think that'll continue. And I think that, and this goes to the other points, that the fact that the federal government has signaled to the United States that cannabis is, if not federally legal, certainly closer to federally legal than it was beforehand, I think it's going to allow you to make moves around the margins, because again, NASDAQ has allowed companies like Weedmaps to list. So, the ancillary companies, I think will continue having an ability to list. Maybe you can get a little bit closer to the plant, but yeah, the license touching businesses won't change because the exchanges still want opinions that say that you're not violating federal law, and you can't really write that opinion for someone that holds a cannabis license, even if it's Schedule 3. In terms of ancillary services, so banking, depository banking services, insurance, payment processing, and we can also throw in debt, bank debt. I don't think this is going to change. It's not going to be a fundamental change because Schedule 3 is still illegal under federal law in the way that the average state operator is operating, right? Which is that it is outside of the FDA's purview. You're not getting prescriptions from doctors. The flower is coming from a facility that's not licensed from the DEA, right? So it was illegal before, it's illegal now, which raises the same sort of money laundering, aiding and abetting concerns that everyone has. But and the big but here is that, for people that are dipping their toes in the industry to date, right, running from depository institutions to payment processors and everything in between, entering the industry has always been a risk-adjusted business decision, right? So while this doesn't change the black letter law, it shifts the risk analysis, right? So I think you're going to see this is going to push people, because what we always deal with at Vicente is, at large organizations, there's always someone there who sees the business opportunity, right? Of we should move into cannabis, there's new business here, right? And then they have to kind of drag the rest of the company along, right? And this is going to make it a lot easier to do that. And yeah, so you'll still see like bankruptcy is still going to be out of the picture because it's still federally illegal. There's still certain IP issues around trademarks. You can get federal trademarks, by the way, but there's some challenges that will remain. So it's not going to change everything. The last thing I'll say, I know I'm a little bit over here, but the reason why Schedule 3 is such good news for the industry is that it solves one of the biggest issues in the industry, 280E. It partially solves capital access and banking access, because I think it'll loosen up the floodgates a little bit. But because it's Schedule 3, your Fortune 100 companies are still going to be very hesitant to directly enter the industry because it's still federally illegal, right? They're going to go to their general counsel and say, is this legal for us to own a cannabis license in Massachusetts? And they're going to say, it's Schedule 3, unless you're following the rules of the Controlled Substances Act, this is illegal. So, there's still a barrier to entry because of the illegality. That's it.
All right. Thanks, Charlie. And thanks, everybody. It's really a pleasure to be on this panel, because I think we've been dreaming about this day for years and years as CPAs in this industry. So just to kind of level set everybody, as we're aware, right? Code Section 280E, if Code Section 280E is applicable to your business, then we end up in a situation where you're taxed on gross margin. In this particular example, you can see kind of a pictorial demonstration of exactly what that means. For a cannabis company in this set of circumstances, in this, with revenue of $1 million, you're going to end up being taxed in this case on $500,000. If you're not subject to 280E, you're going to be taxed on your net income, which essentially is going to allow you, say this is a dispensary, for example, with dispensaries typically being unable to actually deduct things like rent and utilities and other kind of normal costs of running a business operation or running a retail operation. They're subject to a tax rate is significantly more substantial than any other industry that we deal with on a regular basis. So if we skip to the next slide here, what's really important is to think about what is the legislative history of why 288 came to be. And this really kind of comes back to the war on drugs and the issues that happened. So we're not talking 50 years ago when this was scheduled, but we're talking 40 years ago now, when Code Section 280E came into existence under the Tax Equity and Fiscal Responsibility Act. So what happened with 280E to really kind of bring cannabis into its light? If we take a look at the next page on this slide, you can kind of see what was the present law back in 1982. And so ordinary and necessary trade or business expenses are deductible for most businesses in computing taxable income. So what happened, of course, was the case with Jeffrey Edmondson, who was working in the illegal drug trade. And 280E came in as a response to a tax court case, the Jeffrey Edmondson case of 1981, where Congress came to be and said, you know, there is an issue. You can see it right in the middle of this slide. What was the reason for the change in tax policy? Well, there's a sharply defined public policy against drug dealing. They didn't want to allow drug dealers the benefit of business expenses. And what happened in that instance? Well, Code Section 280E came to be. So if we flip to the next slide, it's pretty simple. Code Section 280E has one sentence. So the entire Internal Revenue Code addresses cannabis in a very disproportionate way based upon one sentence. But what I think is really important to note, and what we kind of think about is, well, it'll be great if we see Schedule 3 for cannabis, no longer will we be subject to Code Section 280E because cannabis would be removed from Schedule 1 or Schedule 2 of the Controlled Substances Act, moving it to Schedule 3. But one of the things that allows, of course, is ordinary and necessary business deductions. But not only are we getting ordinary and necessary business deductions, the other piece that you have to take into account is all of the tax credits that have been unavailable at the federal level to these cannabis businesses since the enactment of Code Section 280E. Things like the research and development credit, things like the work opportunity credit. We can have bonus and accelerated depreciation, which is going to spur an investment in fixed assets and really kind of for our manufacturers and our cultivators to be able to actually look at their business through the lens of tax planning will certainly be a significant savings to these clients as they move forward in a world where they're not subject to these onerous tax obligations. And with that, I'm moving on to pass this off.
Thank you, Mitzi. Really interesting questions, been monitoring them on the feed, and, I hope to answer some of them in this section talking about interstate commerce and FDA oversight. So first I want to say that, as mentioned previously on the webinar, Schedule 3 does not make the existing cannabis businesses licensed by state governments legal under federal law, right? So these businesses that, we all patronize, we work with, or we work for, they're going to continue operating under a framework in which they are legal at the state level, licensed and regulated at the state and local level. But because they're not, essentially DEA licensed entities, there's only about, I think, between half a dozen and a dozen of those right now, they're still going to remain federally illegal. So this means that, it doesn't automatically legalize interstate commerce. And because it doesn't immediately change interstate commerce, most of these businesses are going to continue operating. Obviously, their tax, situation is going to change a bit, but they're going to continue operating in the way that they have. Now, that being said, it's possible that we could see some new enforcement memos, and with new Department of Justice guidance, we could see the start of some interstate commerce. So as you may or may not be aware, it's been a number of states. Oregon was the first to pass. California also passed a law, and I think Washington did as well, that is essentially saying, hey, we want to be able to get the jump on interstate commerce once it is federally, I'm going to say authorized, because it's not just legal. A lot of these state programs put in a trigger there that it wouldn't even necessarily require a full change in federal law, but some sort of guidance memo from the Department of Justice or something to demonstrate from the federal government that there is a significantly lower risk of engaging in essentially interstate commerce. Now, how would they do that? This is really going to be something that we'll see if and when a new enforcement memo comes out. And once that new enforcement memo comes out, it's also questionable about, are they going to be able to fly the cannabis, or, is it only going to be able to essentially interstate commerce occur through adjacent states, right? If you're dealing from Oregon to California, that might not be as much of an issue. But if you're trying to go from California to New York, obviously we need to figure out a pathway to do that doesn't, require driving through Kansas and Nebraska. So this is something that's really interesting. Further, I think one of the main things we need to consider is that this move to Schedule 3 is likely going to spur additional federal discussions and federal policy. And I think the main thing we're going to have to look out for, and I was reading an article this morning, is that new enforcement memo. I would imagine it's going to be expanded. Previously the Cole memo just cover the 8-factor tests on what states should do to be compliant with, I guess, federal Department of Justice guidance and the discretion for U.S. attorneys. But I think we would also probably see this apply to in border enforcement. And what I mean with that is, if anyone's been following the news about what's been going on right now in New Mexico, Custom and Border Protection, or CBP, has been, using their ability to police states within 100 miles of the border in New Mexico to go out and basically seize state licensed and state legal cannabis, and that's been a significant problem. We'll likely also see potentially some guidance on banking or international investors. Right now, there's some issues where if you have an international investor, you can't get money from a state licensed and state legal cannabis company out. And so that's a problem. So there's a lot of things we might see with a new memo coming out. Further, let's just talk about FDA oversight, right? There's a lot of concern that, well, Schedule 3 is going to give it to pharmaceutical companies and they're going to just crack down. This is going to be a new Prohibition 2.0. I don't think that's going to happen for a number of reasons. One, even under Schedule 1, the FDCA, the Food, Drug, and Cosmetic Act, can be applied to cannabis, and in some cases, has been. But so far, we've essentially seen a lack of desire to deploy its resources towards mass enforcement. And most of the enforcement that has occurred has been on, medical claims. We've seen that with hemp, and hemp is federally legal. We've seen that with cannabis as well. And so what I think is probably most likely is that the FDA uses its limited resources to go after really the most egregious medical claims by cannabis companies who are trying to, market their marijuana as a federally approved Schedule 3 drug when it's not federally approved yet. It's just that cannabis itself is no longer in Schedule 1. To get federally approved as a Schedule 3 drug, you have to go through the whole process through the FDA to essentially turn the substance into a legal pharmaceutical. So thank you. I'm going to hand it off next to Brian to talk about criminal justice reform.
Yeah, I'll speak about criminal justice reform, and this has been mentioned already, but it's important because I received a lot of phone calls from folks saying, oh, is marijuana legal now? And basically, no, it remains illegal at the federal level and it's under the federal criminal code. So we need to keep that in mind. So our job is not done. But having said that, this is a massive incremental step forward, and it certainly sends a strong message to the criminal justice enforcement arena that they need to sort of reprioritize things around cannabis. And we've seen this kind of state after state, where in Colorado or Massachusetts or California, wherever states legalize cannabis or change cannabis laws in significant ways, there's a ton less prosecutions under state law, right? Because we're changing state law. But frequently we see that federal prosecutions of cannabis crimes go way down in those states as well. I think the feds just get it at that point, that state is not interested in prosecuting adults for cannabis crimes. So I think this will be very persuasive in that sense. And you can look at it sort of more broadly. I mean, we've had a lot of discussion, probably more than ever, at the federal level in the last year or two around cannabis, right? We have Biden and Vice President Harris speaking out and actually taking action in terms of pardons, expungements, things of that nature. So this is certainly an additional step in that direction. I think gets us further down the field on cannabis reform, at the federal level. The sort of red piece here is pretty interesting. That almost every state has a kind of trigger law that indicates that it should the federal government change cannabis's position from Schedule 1 to Schedule 3 or something else, then that state has to sort of do an assessment of their own state scheduling system. So the way it works is you have criminal laws at the state level, and there's a schedule of drugs at the state level in addition to the one we have at the federal level. But those triggers do not take place like automatically. They set a process in motion in those states, and I think it'll start a discussion in those states about what, where should cannabis be? Should it be the same place as at the federal level? So that'll be a sort of symbolic win. At the end of the day, almost all state criminal laws are really based on volume, right? How much cannabis do you have, or how many plants do you have, as opposed to, this is a Schedule II substance, so we should prosecute it in a certain fashion, right? So I think it'll be persuasive. I don't think we'll necessarily see this be like a wholesale shift immediately in how prosecutors across the board treat cannabis. But I certainly think, as we've seen state after state, as reforms come through, generally laws get better in terms of prosecution, enforcement priorities get better in terms of cannabis and its place. So I'm going to turn things over to Sean. We've talked a bit about the potential Cole Memo 2.0, and some of us were listening to Representative Blumenauer speak about this yesterday. So Sean, do you want to jump in and we can keep moving the ball?
Thank you. Yeah, I mean, I think it's critical we all kind of focus on the work ahead and the end game here, which really is congressional reform, and also, this updated enforcement memo that stabilizes and makes healthy the state markets on the way there. As we've all acknowledged, Schedule III is limited. We're still under DEA purview with no interstate commerce, with this FDCA oversight intention. And as we've acknowledged with hemp, FDA doesn't have a structure really suitable for cannabis or botanicals, and we lack very important protections and criminal justice reform. Only Congress can address these challenges. And I think especially with the hopeful injection of capital with the 280E removal and the hopefully renewed investment in momentum, it's critical we organize and engage to use this momentum and be resourced to get descheduled through Congress. And, obviously it's difficult to get any kind of cannabis reform or many reforms, through Congress, and it's a critical election year. We don't know, what the administration is going to look like, but there's more support than ever, and education and discussion than ever on cannabis reform. Spurred by this issue, we saw the Cannabis Administration and Opportunity Act reintroduced this week, which is comprehensive legislation that would end prohibition by fully removing it from the Controlled Substances Act, and allowing states to create their own laws, and also having meaningful criminal justice components like expunging past convictions and restorative justice components. There's also States Act 2.0, certainly safer banking, all critical reforms. I think these legalize and regulate structures are unlikely to pass in the election year in a divided government. But I think even the education and discussion moves the ball forward. And, with Schedule III and legitimacy from the medical community, we can have as much success as possible in, continuing to make sure these reforms stay in play and ultimately getting them passed in years to come. And, I think with rescheduling and public opinion changing with medical legitimacy, we're better resourced and in the best position we've been to date for congressional reform. 70% of adults support legalization, the highest level yet recorded. And, with 38 states legalizing medical marijuana and 24 for recreational use, we, have bipartisan leaders in states that sets the stage for Congress to put forward a regulatory framework that, makes sense, legalizing and regulating cannabis, and in my opinion, with a more limited role by the FDA. But, I think at the end of the day, this is critical incremental progress and a huge shift in policy that we've got to organize and utilize for congressional momentum on all fronts. And I'm encouraged by, kind of the organization and, healthy debate that we've seen by the industry as a part of this process. So I think even though a lot of folks disagree on the ways to get there and how to get there, most agree legalizing and regulating is the end goal. And if we can organize and engage, we can really do a lot with this incremental progress. You know, and on that note, there's a lot of folks doing incredible and, you know, game-changing work on this, including the Coalition for Cannabis Scheduling Reform, which we're proud to be a part of, USCC and other groups. We are, you know, really all heads down focused on the work ahead, which is this critical public comment period. I think it was announced today, you know, Kevin Sabat and friends of a legal defense fund and are, you know, going to get everyone they can to challenge the medical research and the new standards here. And this is a mission critical process for us. The work is not done. And, you know, generally when when the federal government's rescheduling a substance, it's an FDA approved drug. It's not a botanical, you know, the history here is challenging, and this process is novel. So we've got to really show up with the best team and know that the law and science is on our side, and really do everything we can to participate as much as possible in this process. We'll be sending out some resources to everyone that's registered about how to help. I think, you know, the science and law are on our side for anyone that has physicians in their network, you know, chief science officers, you know, who can speak to the good research supporting the medical use and treatment in cannabis that's gone on in the 38 medical states, that can speak to, you know, other federal and international research. We need as many of those comments as possible. And, you know, we need to get organized as soon as possible. So don't hesitate to reach out to us if you are able to help, and we will share some resources as well. And I will take some, I wanted to share this. I thought good quote from Senator Schumer on the announcement that, you know, I think just highlights the work ahead, and you know, more to come.
And yeah, sorry to jump in here. I just wanted to mention one thing I neglected to mention in my segment, which is, right, so, you know, 280E is still in effect. And it's not going to go away until we're officially on Schedule 3, right? But what some companies are doing, and this is something you got to talk to your tax advisors very carefully about, but what some companies are doing is they are filing their taxes now as if 280E didn't apply. And they're doing this because they think that there's a reasonable basis to take this position based on arguments around sort of the unconstitutionality of 280E applied in today's framework. It's pretty nuanced, but this is basically the argument that David Boies is making in the case in Massachusetts in federal court. So in order to do this, in order to file your taxes like this, you have to sort of clearly disclose to the IRS what you're doing, and you also need to have, you know, an opinion of counsel, so you can say you have a reasonable basis. And this is necessary both for the tax filer themselves as well as the accounting firm that's preparing the tax filing. So, you know, we spent a lot of time this week thinking about this, and we're comfortable now taking the position that there's a reasonable basis to take this tax position for certain companies, that you do have to sort of look at the facts and circumstances related to the specific company in terms of, do they have all their assets, you know, close to a state border, let's say, or, you know, do they have different LLCs for their different licenses? So in any event, it's something that you should consider if you're trying to essentially conserve cash flow in the short term. Certainly no guarantees the IRS is going to agree with that tax position. They can always come back, and even if there's no penalty, there would still be interest. I'm not a tax attorney, but if you want to talk about you know, reasonable basis, tax opinion, please don't hesitate to reach out. We can connect you with the right people. Thank you.
Thanks, Charlie. We've got a lot of great questions. I'm just gonna start rocking through them, and if we don't get to your question, we have them here, and we'll reach out, and feel free to reach out to us as well. We'll put everyone's contact information up at the end here. A few notes on process, just kind of the tee off what I was saying, and that, you know, expect this process to be highly challenged, specifically, you know, whether there is sufficient research with the, you know, DEA and opponents insist they're not. And Jason, this one is for you. How does one become an aggrieved party with standing? in this process that can seek judicial review? Can it be anyone? Do they have to make a comment during the public comment period to get standing?
Yeah, so it can't just be anybody. They do have to submit a comment during the comment period to maintain their ability to bring a legal challenge afterwards. But in addition to that, standing itself is a legal requirement. So district courts, circuit courts, they have some leeway in kind of determining what satisfies this requirement, but there is an overarching obligation that to have standing, you must be individually harmed by the action being taken. It can't just be a general harm that all of society faces. And so I think a good example here would be medical patients under state programs. They've been able to bring challenges to Schedule 1 classification because they're arguing that they themselves are being harmed by having marijuana on Schedule 1 because they're unable to satisfy federal law by taking the medication that their doctor is recommending. And this applies to being able to access guns and all of that. So that's an individualized harm that a patient has. What would be difficult under moving marijuana to Schedule 3 for someone to satisfy standing is there really is no harm that would occur to an individual for this. Schedule 3 really doesn't change much as far as requirements to receive DEA registration to ensure that you're not participating in the diversion of marijuana. So there really is no additional harm that would be created. So I think it would be very difficult for someone to show that they were individually harmed by a move to Schedule 3.
Thank you. I think that's a really important thing to know in the process ahead. One more question on process for you, Jason. What is the form of the actual rule that would be published in the DEA's final rule? Is it just marijuana is now in Schedule 3, or would the actual rules be added? Like the regulations are on complying with international treaty obligations?
Yeah, we expect that the rule is going to include both that marijuana is being moved to Schedule 3 as well as additional regulations to ensure that the move to Schedule 3 maintains certain restrictions that are required under our treaty obligations. And so it's going to be an extremely long rule because they also have to publish everything that they use to base that decision on. But yeah, we expect that it will have both we are moving this to Schedule 3, and also here are some additional regulations that we're doing to ensure that we comply with our treaty requirements, which is exactly what they did in 2018 when they moved Epidiolex, which at the time still fell into the definition of marijuana. They moved it to Schedule 5, and then they added additional regulations to ensure that import-export requirements were maintained. They're likely to do the same for registration, as well as some additional obligations that they need to adhere to.
Thank you. There's a number of questions here with respect to how reclassification might affect hemp, which is really interesting because to highlight that marijuana's classification is ridiculous, we already have hemp completely removed from the Controlled Substances Act via the 2018 Farm Bill. And with innovation in the plant, we really have high THC products that are similar to marijuana in the regulated market, sold without DEA control and Controlled Substances Act regulation all over the country. And, in my opinion, that really highlights the imminent need for full regulation of the whole plant. The reclassification of marijuana to Schedule 3 doesn't impact hemp. Hemp remains off the schedule entirely. There's certainly, some hemp products like some synthetics that DEA has said they believe are controlled substances. So are still marijuana. So to the extent something is considered marijuana, it would be Schedule 3. To the extent something's hemp, it would be descheduled. Obviously the definition of hemp could change in the upcoming Farm Bill. That is, potentially pretty far off. We're hearing September at the earliest, but potentially 2025. So I wouldn't expect a change to the federal hemp definition in the near future. Switching to a couple of 280E, good 280E questions here. What categories of expensive for cultivation would be helped by elimination of the 280E, or would it just help retail enterprises? And Mitzi, maybe that's one for you.
Yeah, I mean, one of the things that, again, 280E limits is federal deductions. It also really kind of goes back to the tax code in place back prior to the enactment of 280E. So some of the things like accelerated depreciation, bonus depreciation, some of the kind of newer tax positions and newer tax kind of regulations that have come out that help a lot of modern businesses are not applicable to cannabis businesses. So if you're a manufacturer or cultivator, you know, probably the biggest change that you would see really relates to accelerated depreciation from a timing perspective. You know, the ability to deduct any selling, general, and administrative expenses as a cultivator or manufacturer that you haven't been able to do so under 280E, of course, is certainly a benefit. But I think, you know, the big kind of unknown out there is really the tax credits that are available to you, the tax structuring that's available to you, kind of really taking a look at the tax situation of your business and being able to plan for those things that otherwise have not been available to you. So, well, you know, retail business that did not go through a 471C analysis and kind of took a maybe more aggressive position on a retail side will still see plenty of benefits from 280E, you know, as a cultivator or manufacturer.
Thank you. And I know there was a number of questions about clarifying that the Schedule 3 does not mean marijuana or all FDA approved drugs are sold through entities that are, you know, licensed to prescribe marijuana, because the state businesses are not. But that marijuana would now be Schedule 3, not Schedule 1. Does that have any impact on 280E? I mean, businesses, state businesses will still be able to qualify for 280E, even though they're not selling not selling FDA approved drugs, because they're not trafficking in Schedule 1 or Schedule 2 substances, correct?
Yeah, I mean, there's a provision in the one sentence of Code Section 280E that really kind of states that, you know, you can't take these deductions or credits if you're consisting of trafficking controlled substances, again, within the meaning of Schedule 1 and 2 of the Controlled Substances Act, which is prohibited by federal law or the law of any state in which such trade or business is conducted. Well, that probably is more of a legal interpretation for the legal community to determine what that means. I think that's where a lot of people are kind of getting tripped up from that perspective and looking at it from a, you know, what's the applicability of 280E to my business if there's a state issue.
Thank you. And a couple of questions on a very legitimate fear, you know, how could a new administration, potentially a Trump administration, potentially turn back the clock here? Could a new administration reverse this process? Jason, do you maybe want to speak to that?
Yeah, so I think this is, I mean, I already spoke of it a little bit, and under 21 USC 811D1, which is the treaty requirement, the Attorney General of a future administration can basically say that under our treaty obligations, I believe that marijuana needs to be in Schedule 1 or 2, and so we're moving it there without going through any notice and comment, any HHS evaluation. That is in the code, and would be at least statutorily a legitimate move. Where that I think would run into issues would be during the litigation, because I don't think that that is legally justified. So that would have to go through the court process. Another potential concern is if this process to issue a final rule doesn't conclude before, let's say, Trump takes office in January, if that were to happen, then they could just decide not to continue, or they could decide not to or defend litigation. All of that, though, would raise litigation concerns, and there wouldn't really be too much of an issue of showing standing there as well. So pretty much if the Trump administration, if Trump wins in November, comes in and tries to change everything, it's going to face litigation. I mean, I do think even though you have a lot of Republicans saying that marijuana should not be on Schedule 3, you also have a lot of Republicans in states that have now legalized. And so they're going to probably get a lot of pressure from their constituents that Schedule 3 needs to happen. And so I'm not sure how much of an appetite they would have to do this, but it's always a potential risk. And that's why, big thing, talk to your congressperson. 811D1 needs to be repealed to ensure that future administrations can't just do this.
Thank you. And Charlie, this one's for you. A couple of questions on how reclassification could potentially lead to, or not, lead to uplisting. Could there be any impact?
I think it's going to be at the margins. I mean, I think that like the exchanges will look at these companies on a one-off basis, and I think if you got an argument it's legal, they'll consider it. But I don't think you're going to be able to take. I mean, if you look at these companies that have uplisted, sort of like TerraSend, which started the process, the entity that's listed on the exchange does not hold any licenses. It may have an arrangement with the license holding entity, but the license holding entity doesn't list on the exchange, and that I think is the red line that they're not going to budge on. But as you can see from like TerraSend on down, like these exchanges are open to sort of structures that permit that could get people access to the capital markets.
Thank you. And a couple of questions around, are there possibilities that state dispensaries in legal states could convert to pharmacies and be fully compliant with Schedule 3? Unlikely, again, Schedule 3 means FDA approved drugs, which are only Epidiolex and the 4 synthetically approved cannabis drugs. It's not, the flower gummies or other products sold in dispensaries, and dispensaries don't have the federal registrations or requirements and controls that meet federal requirements. So again, it'll likely be status quo for the dispensaries. They'll remain operating in contravention of both the Controlled Substances Act and the FDCA, and under the hopefully continued and updated favorably enforcement approach of the administration. But that's why I think it is critical we work to achieve another enforcement memo. And Brian, maybe you can answer this one. We have a couple of questions on, who is kind of this primary opponent, Kevin, Sabet, and Sam, and kind of thinking about what we need to be ready for here.
Yeah, so I mean, the opposition is organized and funded at the end of the day. And we've been battling these folks. I've been doing it for 20 years, and I see some friends, Ethan Nadelman, others on the line here that have been doing it for 30, 40 years. And so they're not dummies, right? We have public opinion on our side. We have more and more states legalizing cannabis. We have this common sense decision or impetus from the federal government for the first time in years that something needs to be more done on cannabis and it should be moved to Schedule 3. So there's a lot of momentum, but it is, as we said at the beginning of the hour, it's going to take a movement-wide effort really to make this happen, right? And we will be involved in helping to coordinate folks' comments on this. I think a volume of comments is going to be needed to get this done. They'll have to be sophisticated, and so there'll be chances for really big businesses, small businesses, stakeholders to participate in this process. But we can't take it for granted. But it is, we have a good shot at significant progress, which will provide relief for many cannabis businesses, but also just generally move the ball down the court for cannabis reform, and that's really what we wake up trying to do every day. So, Sean, I'll turn it back to you to maybe close us out.
No, thank you so much. That's the perfect segue. I have the link up here for the Coalition for Cannabis Scheduling Reform, where they're doing incredible work and organizing comments. And as Brian said, our opposition is well organized. We can do better because the medicine and science is on our side, as is the law. So especially if you're a business who operates in a medical cannabis state, who knows doctors, knows researchers, can speak to the medical use and treatment in your facility, in your state, your comment matters. We can help guide you and how to submit the strongest comment possible. We can plug you in with the coalition, and we'll reach out with some resources. we also, the coalition and other stakeholders here, we've got a whole industry working on engaging in this process. We really need resources to get it done. We've got to prepare for potential litigation that we know is coming. We've got to support physicians who are reviewing all of these studies and preparing comments. We've got to continue to work on government affairs on getting through this process. And this is really the critical next stage, and things like the enforcement memo. So please consider, donating, supporting. Everything matters, and we will share some links on how you can do so. And thank you so much for participating. I know we didn't get to all the questions, but don't hesitate to reach out to any of us. And I really appreciate your time and engagement here. Thank you.